Ready.
Yes, good morning. Am I coming through okay?
You are. Thank you.
Great, thank you. Good morning, Your Honors. Eric Levine for the appellant, Deutsche Bank. I'd like to reserve 5 minutes for rebuttal.
Very good.
Okay. The order of involuntary dismissal should be reversed and this matter remanded for further proceedings. The trial court committed two distinct yet related errors, either of which requires reversal. First, the trial court erred in granting involuntary dismissal by improperly weighing the evidence when a prima facie case was established. And second, the trial court compounded that error by excluding the judgment figures from evidence when a sufficient foundation for admissibility had been laid. With respect to the first error, with respect to involuntary dismissal, to establish a prima facie case, a foreclosure plaintiff must prove four elements. So probably everyone on this panel knows them as well as I do. One, an agreement between the parties, default by the defendant, acceleration, and amount due. There's no dispute here. Everyone agrees we proved elements 1, 2, and 3. The only issue is 4. Did Deutsche Bank introduce some evidence of the amount due? Some evidence of how much was owed? And the answer, of course, is yes,
So
absolutely.
let me ask a question on that. The trial court heard an examination on documents that were tendered as business records, and the documents had been altered or manipulated, depending on how you want to characterize it, the week before trial. So they were not, the business records that were being offered were inconsistent from the inception of the loan or the default period until they were offered at trial. Why was the trial court wrong to exclude those from evidence and basically conclude the bank? I think this isn't a exact quote from the judge, but a paraphrase that these records are all over the place, and these records do not reflect business records made at the time of adjusting pre-modification, post-modification interest rate changes. Why is the judge wrong on that?
So that's the second issue that I'll jump ahead, of course, for you. Why was the judge why did the judge abuse discretion in excluding the judgment figures? The reason the judge abused discretion excluding the judgment figures is for the exact reason you said. The judge took the judgment figures that was proffered, that was obviously not in evidence, compared it to two other sets of judgment figures that were also not in evidence, and
But
said,
you would agree, though, those judgment figures that were being offered was not reflected in the records that were being tendered.
I'm sorry, I don't understand the question. The judgment figures that were being
The payment history, transaction history, the records that the witness was offering through counsel reflected numbers that differed from those that the trial court was asked to accept as correct.
I would say that the payment history reflected an amount due, and the judgment figures that the witness explained what occurred in this case. The witness explained that there had been the loan had been given what's known as a refresh model. I wouldn't really use that term to help Ms. Cajeo stay in her home, and they backed it out before trial, which is obviously what happened in the Leones case that I cited in the brief.
But
But
that was not reflected. Those changes were not reflected. I should change my wording. The numbers that were being offered at trial by the witness were not reflected in the business records of Carrington, correct?
it depends on which one you're talking about. They are reflected in the judgment figures that were excluded. The payment history, I think, that was offered did not go all the way through when it had been backed out. But in any event, I understand the
So
court's
what Carrington had done, based on the witness's testimony, is made multiple adjustments. One dealing with increasing the principal, then lowering the principal, and then interest rate changes that were not fully documented in the transaction history or the records being tendered, correct?
the interest rates are never documented on the transaction history. I will say that. So
Are
partially
you
correct.
saying there is no written documentation that would reflect changes in interest rate in the bank's records?
No, no, no. Of course, I'm saying specifically what was entered into evidence. The judgment figures that we attempted to put into evidence, I believe, would have reflected it.
The judgment figures that
Yes.
were not part of any of the business records that were being offered to the court.
Well, we offered it to the court, but the
You
court,
offered a judgment to the court,
well,
not a prepared bank record,
well,
correct?
we prepared, no, we offered on page 1512 of the record, judgment figures. But I would say that what you're getting at, Your Honor, is that there might be some discrepancies in the evidence and maybe some inaccuracies in the records. But the question before the court on de novo review today and the question before Judge Barthel at the trial on involuntary dismissal, is there any evidence of the amount due? Is there anything before the court that shows the amount due? Not whether or not how good the evidence is or if there's discrepancy, because by definition, if you say, well, this evidence conflicts with something else, which is exactly what Judge Barthel said on page 1620 and 1621 of the record, she said, I have something before me that says $125,000 was due, which is correct. That was admitted into evidence. But there's discrepancies with something else that says possibly 130 was due. But as a matter of law, on involuntary dismissal, that is by definition weighing the evidence. And so the question before the court was, is there any evidence of the amount due? Any evidence? And the answer to that is yes. The original note itself is evidence of the debt. And the case law in Florida, Jacobs versus Beck, Knauer versus Levy, all say, when you put the original promissory note in evidence, which in this case shows $132,000 was borrowed, that alone establishes a prima facie case. Just the promissory note under Florida law.
But the witness's testimony changed that.
I disagree, because if you're talking about the witness testimony changing it, by definition, you're talking about weighing of the evidence.
Well, but this is the bank's own witness who is providing conflicting testimony and conflicting documents as to what amounts are being requested by the bank and why. So ultimately, isn't this question I'll again change the wording, isn't the trial court entitled to say that you have not established an amount due that is supported by the records, therefore the case is dismissed?
I would say no, not on involuntary dismissal. If we had gotten to if we got to the close of the evidence where the judge becomes the fact finder and can at that point weigh the evidence, maybe. I'll give you a maybe. But in terms of involuntary dismissal, the question isn't discrepancies in the evidence. The question is missing evidence. If you take all the evidence that was entered, presume everything's true, give Deutsche Bank the benefit of every inference, no weighing of any discrepancies, do we establish a prima facie case? And the answer is simply yes, because the witness testified that $125,000 was due at the time the last payment was made in September of 2008. Judge Barthel made that exact comment on the record when she made her ruling. She said, on page 1620 of the record, line 23, I see the 125,613.85 as being the principal balance after the last payment. She noted that. The witness testified to it. You have the original note and evidence. All that combined, even if there's other evidence that might be to the contrary, you don't weigh it on involuntary dismissal.
Go ahead. Go ahead, Mr. Judge.
Go ahead, Judge.
No, you go ahead. I'm good.
To follow up on Judge Silverman's original line of questioning, and then kind of what you just said, maybe break it down. What is the unaltered? We talked, that may be the wrong term, but there was alteration to back out the whatever we call the modification, refresh modification. What unaltered documentary evidence, bank records were admitted? Or attempted to be admitted. So the payment history, is that right?
So the payment history is in evidence without objection. The testimony from the witness of 125 doing at the last payment was testified without objection. The judgment figures were excluded, which showed the 125s, which what we were seeking. So what happened here, and I'll.
So 120. So wait, let's back up. So the payment history shows that 125 is owed.
At
125. At what? Go ahead.
At the time of the last payment in September of 2008, the payment shows 125.
Okay, and then the testimony of the witness testify that to that number.
That's what the witness said we were seeking. Yes.
Right. And then the excluded evidence was different.
No,
right?
No, Your Honor. The excluded evidence on page 1512 of the record also said 125. What happened?
So, and that was compared to the judgment figures, which was different.
So page 125 was the judgment figures. What the trial court compared it to is on page 1700 of the record and page 561 of the record, those which are obviously not in evidence either. And those records are also judgment figures that had different numbers in it because I don't like the term.
One was at summary judgment, right?
Yes. One was attached to summary judgment. One was, but remember, none of these were in evidence. And so
one was attached, let's just lay it out. One was attached to some summary judgment, and the other one, where the other one come from?
I believe it was just emailed to opposing counsel or produced in discovery. So,
Right.
so the first error, involuntary dismissal, even putting aside the judgment, let's put aside the exclusion of the judgment figures. Even without the judgment figures, the evidence showed an amount due, some evidence of the debt, both the promissory note, the witness testimony, and the payment history. I understand Judge Silverman's point. I never shied from it. I don't believe I pretended that there's no conflicting evidence here. There certainly is. But I'll give you an example, a very basic one. If I'm a witness to a car accident and I put in an affidavit that says, in summary judgment, says the light's red when the car went through the intersection, and then I go to trial and I say, no, the light was green. Is my trial testimony inadmissible because I said something different previously? Of course not. I can be impeached. I can be cross-examined. My affidavit might be used against me on rebuttal, but it's not an evidentiary issue. And let's say we get to that car accident case. Let's say we get to the end of the plaintiff's case and they move for involuntary dismissal and they say, Judge, Mr. Levine said red at one point and green at another point. He can't be trusted. He's changing his testimony. Involuntary dismissal denied. Because I said if I said something that supports the plaintiff's case, you can't weigh it on involuntary dismissal. So in this case, I get it, Judge. The Ms. Cajallo's loan balance was recapitalized to hold her current in 2008, 2009, so she could stay in her home. She never made a payment under it. And right before trial, we corrected it and went back to the true numbers. And actually, I will point out that on page 1594 of the record, Mr. Wolf at the trial said, talking about the judgment figures we wanted to enter into that evidence, he said, right, they're correct now. That's on page 1594. So we all agree that the judgment figures that we wanted to get into evidence on page 1512 was correct. So my first issue, involuntary dismissal needs to be reversed because we did establish a prima facie case. I understand there's some discrepancies and maybe some alterations of the evidence. I don't like the term alteration. I prefer the term updating or correcting. But regardless of that, those aren't weighed, and as long as any evidence shows an amount due, whether it's $1 million or $1, as long as there's any evidence of an amount due, involuntary dismissal is denied because we've showed we're entitled to a judgment. Maybe a judgment for 125, maybe a judgment for 130, maybe a different number, but as long as the evidence shows entitlement to a judgment of a amount, involuntary dismissal should have been denied.
Was anyone suggesting a different number other than 125 or 130, one or the other?
I do not believe so, and I don't believe anyone's ever taken the position that nothing's owed. Certainly no one's taking the position that loan was paid in full and this should be satisfied. But going to
is there an amount that everyone agrees to is at least a minimum that's owed?
Well, if the two numbers are 125 or 130, I would imagine
that's what I'm saying is that the difference between the two camps is about 5,000. Is that right?
I believe so. And I would say yes.
And then can I follow up with that, Mr. Levine? The bank is only seeking the 125. The bank is seeking the lower amount.
That is correct, Mr. So the 5,000 difference was added to the principal balance in January of 2009. It was the past due amount. They recapitalized it, hold her current, and said, because I know if everyone remembers what was going on in foreclosure world in 2008, 2009, the bank here tried to do the right thing. Maybe they did it the wrong way, but they tried to prevent foreclosure of this home.
Well, we don't really know that because we never got to the defense case, did we?
We didn't get to the defense case, but we have Mr. Greenlee, the witness, explaining.
So I appreciate your characterization, but we don't have evidence saying whether it was done with good motivation or not. I understand the bank's position, but let me ask you one question. You first asked for reversal and remand for entry of final judgment in favor of your client. You then seem to correct that in your reply brief that you're not entitled to that, correct?
I asked for that because I didn't anticipate. I was under the impression there wasn't going to be a defense case, but Mr. Wolf in his answer brief said he was going to put one on, and I took him at his word, and I said, "You're right."
Did the defense rest?
No, they didn't. That's
So
why
there was no opportunity to provide a defense case, was there?
No,
that's kind of part of your argument, right? That the defense didn't rest because this is an involuntary dismissal after the plaintiff's case.
Which is why I specifically said, you're right, this should not be sent back for judgment. But I want to speak to a moment about the exclusion of the judgment figures. Now, of course, I don't believe the court needs to reach the issue because I think even without it, it should be reversed. But let me explain the problem with how the court excluded the judgment figures was that the court took the one we wanted, page 1512 of the record, compared it to two other sets and said, there are discrepancies. I believe she said something like, I can't reconcile these. I think that's the word Judge Barth used. I can't reconcile these. That is, as a matter of law, an abuse of discretion because by definition, that's weighing the evidence. And I looked hard for cases, and I asked why in my reply brief in response to this argument, I cite federal cases throughout the country, but they all kind of say the same thing. Inaccuracies in the record, possible alterations, just as you pointed out, they all go to weight. They don't go to admissibility. And I'm reading here from a case, let's see, it's a Eastern District of Texas case from 2013, and it says, the mere possibility that computer information may have been altered goes only to the weight of the evidence, not its admissibility. And so I would say that what should have happened the court should have admitted the 512, the one judgment figures we wanted, and then Mr. Wolf could have put was free to put the other judgment figures in evidence in his defense case, and then the court can weigh them. That's how it goes. When there's contrary evidence, sorry.
Mr. Weinstein, let me just, while you were taking, and I said Mr. Weinstein, Mr. Levine, while you're taking a breath, you are at your 5-minute mark.
Okay.
So I will, if you want to reserve the rest of your time.
I do. I just want to say, I think, as I said, the court abuses discretion excluding the judgment figures because it weighed the evidence improperly. And then finally, very last, there was a reformation count that was dismissed that I believe the appellee stipulated in his answer. Yes, that one we are okay with reversing for judgment. So with that, I would ask the court to reverse and remand for further proceedings or a new trial, and I will reserve whatever time I have left for rebuttal.
Very good. You'll have 4 minutes left. Thank you.
Thank you.
Mr. Wolf.
Good morning, may it please the court. Matthew Wolf on behalf of the appellees, the Del Calejos. We're going to ask the court to affirm the trial court ruling of the involuntary dismissal. This was a strange case. This was a case where the plaintiff unilaterally modified my client's loan in 2009, added on principal balance to that loan. After 15 years and 8 years of litigation, 7 days before trial, they try to unwind that transaction and say a different amount is due and owing than the amount that we unilaterally modified. I haven't seen anything like that in my 15 years of doing foreclosure work. The two issues are, counsel kind of didn't have the opportunity, but glanced over this idea. He argues that they just had to put on some evidence of damages. That's not what the Green Emerald case says. The Green Emerald case says if you're going to prove your damages in a foreclosure, you have to do so through competent, substantial evidence. And they didn't do so here. He tried to test Mr. Greenlee tried to testify about the unpaid principal balance. And then if you compared it to the payment history showed a different amount. If you compare it to the collection notes that were admitted into evidence, it shows a different amount. Then when he was questioned about the corporate advances, the taxes and insurance, the interest, he couldn't point to anything to support their claims for their damages. And I even asked him at one point in time, you're just looking at the judgment. I know you can't see what he's doing through the transcript, but I asked him, you're just looking at the judgment, aren't you? That's what he was doing, just looking at the judgment. Green Emerald says you have to prove your damages by competent, substantial evidence. And if you don't, involuntary dismissal is proper. The Green Emerald
let me
case,
ask you about Green Emerald. So what do you think about footnote 6? We know that 21st Mortgage has not argued that there are components of the amount due that were sufficiently proved, notwithstanding the absence of evidence with regard to the loan modification to which its witness testified. And then in that footnote, they cite to Boyette, which seems to potentially support the bank's case here that involuntary dismissal wouldn't necessarily be appropriate. In other words, what do you make of that footnote 6? You think that this court was saying, well, if the bank had argued essentially what the bank's arguing here, then maybe involuntary dismissal wouldn't be the proper resolution?
Honestly, Judge, I think when you compare this case to Green Emerald in that footnote, what you have in this case is you had the bank beating the trial court to the punch. Okay. In the Green Emerald case, They were trying to collect $77,000 of principal that they could not substantiate. And the trial court says at the end of the day, said, okay, you can't prove this amount, but you're able to prove a lower amount, and that's good enough. And the second came back and said, no, that's not good enough. You have to prove it through competent substantial evidence. The bank did here is they just beat the court to the punch. Said we have pled in our complaint 130,000. We have argued in our affidavits in support of motion for summary judgment 130,000. We have a payment history and collection notes of 130,000. We cannot prove it. So a week before trial, they alter their judgment figures and they come and prove a lower amount than what they pled, a lower amount than what they demanded, a lower amount than the payoff figures they gave us throughout the entire case because they couldn't prove it. They are in the same exact position as the bank was in the Green Emerald case, just one step ahead of the court. That's it. This is the same exact case that you have here. Just one step ahead.
But are you going to address my question about the footnote? Could the footnote be read to mean that had the bank had 21st Mortgage made the argument that the Deutsche Bank is making this case, that involuntary dismissal wouldn't be the correct remedy?
I think that's up for interpretation.
Why did they put the footnote in there is what I'm asking.
Why they put the footnote in there, I don't know, Judge, but they did reverse and remand for instructions for involuntary dismissal. To say that involuntary dismissal is improper when you can't prove your damages by competent and substantial evidence takes Green Emerald and it throws it in the trash.
So the footnote 6 is placed right after the sentence, we reverse and remand for the trial court to enter an order of involuntary dismissal, which was the remedy Green Emerald properly sought in the trial court. And then the footnote says, we note that 21st Mortgage has not argued that there are components of the amount due that were sufficiently proved, notwithstanding the absence of evidence with regard to the loan modification. So why do you think they put that footnote in there?
I don't know why they put that footnote in here, but they haven't sufficiently proved anything in their case in chief. Even the unpaid principal amount is not supported by their payment history. If you look at their payment history, what he's doing is he's citing in a number from 2009, not the most recent amount that they show on their payment history. If you look at their collection notes, it's a different number.
Let me ask you this: what if the judge didn't involuntarily dismiss and you put on a case that impugned the 125 figure? I was thinking that you could at some point conform your pleadings to the evidence, but they wouldn't need to, right? They could just say, you know what, fine, we'll take the 130.
They couldn't establish that. That's why they had to lower it. They couldn't establish that because they unilaterally modified the loan.
Because the modification, they admitted that the modification was unilateral.
They admit
it seems like it's so I see the dilemma. So yep, they admit the modification is unilateral. So if they admit the modification is unilateral, and then they have evidence that without the modification, 125 is the correct figure, isn't that evidence that your client owed 125?
They have evidence. Their payment history showed a different amount. Their collection notes showed a different amount. He testified that they just altered
different amount than what? Different amount than
what they were seeking. They were seeking 125.
What if could they move to conform their pleadings to the evidence?
Potentially, but they didn't do that. They tried to.
They didn't do that. Well, that all depends on whether this court decides that involuntary dismissal was not prematurely granted, right? Because if it wasn't, they could move their pleading. They could. So what is your argument? So is your argument that, and what was the judge's argument? Their judge's argument was that you would agree there is evidence. There is some evidence of the 125 amount due as of the last payment, right?
My argument is that the evidence the documents they admitted into evidence indicate a different amount than what they were seeking in the judgment.
What amount?
130,000 and some change.
No. What amount did the payment history admitted indicate was the amount due as of the time of the last payment?
Their payment history in 130,000. This is where it's distinguishable from the Leon's case. In the Leon's case, when there was issue over a loan modification, they admitted to evidence the payment history showing that everything was unwound and turned back to the original amount. That was what they admitted. They didn't do that here. They just altered their judgment figures a week ahead of trial. and it wasn't supported by their payment history. What he's doing is he's citing a number to you from 2009, not from the default date that they have alleged in their complaint. I have a credit card. If you go back far enough, you'll find that there was a zero balance due. Could I argue that that's all that's due? Go back that far? If you look at the record, the most recent amount is the 130. They didn't catch this until 8 years in the litigation. I specifically pled it as well. Paragraph or affirmative defense number 5 specifically says, you've unilaterally modified this loan. You increase the amount due and owing without my client's consent. You're not going to be able to prove your damages. And they weren't able to do so. And they weren't able to do so because those judgment figures were left out of evidence because they were not trustworthy. That was what was before the court. You notice he didn't use the word trustworthy at any point in time. 90.803 subsection 6 says a business record is a hearsay exception unless you can prove it's untrustworthy. How did I prove it was untrustworthy? By using their own business records. They had an affidavit of amounts due and owing. They moved for summary judgment under a unilateral loan modification indicating $130,000 was due. The second judgment figures that I produced, that was given to us as an exhibit for the prior trial. We had a trial scheduled a few months ahead of time. The judge got sick and she had to reschedule. And so those are the judgment figures given us as their evidence at the prior trial. And then the third one we received were the ones for this trial. All Judge Barthel had to do was take the documents I proffered, their own documents. This isn't anything we produced or we had to obtain from a third party. It was their own documents. Confirmed, one of them confirmed through an affidavit of penalty of perjury of what was due. And all she had to do was place all three of them next to each other. And they did not match. And I think she even said it in her testimony in the transcript that if you have a business record from 2009, it should look the same as in 2014. And if you pull it again in 2020, it should look the same. And if it doesn't, then you can't trust it. And that was the issue that they had, is she literally placed all three of them next to each other and says, I can't reconcile this. You're telling me that this is going to be trustworthy. None of this is the same. If I pull my credit card statement from March 2009 today, and I pulled it 5 years ago, they should be identical. And if I pulled it 10 years ago, they should be identical because that was the record at that time. And that's how they laid the foundation. But if you lay the foundation through the business record deception saying...
Let me interrupt and interject because I think a point that maybe you're trying to make, or at least I think you're trying to make, is the testimony offered was not competent testimony because it relied on business records. And the business records did not accurately reflect, conceded by the witness, did not accurately reflect the amounts due. Is that what you're trying to argue?
Yes, Judge. And
the witness was not a competent witness to adjust the amounts being claimed on the fly.
You couldn't establish that. Correct. I asked him, how did you come to these interest rates? This was an adjustable rate, no. And if you look at the document that was excluded, it wasn't an adjustable rate. I asked him, how did you come to this interest rate? He said, it's better for your client. He couldn't establish where these numbers came from. When you compare that to the Leon's case where they actually backed out that loan modification, the court said, look, they actually, in their business records, when they unwound everything, it shows that they reverted it back from a fixed rate to an adjustable rate. You won't find that anywhere here. And he wasn't able to substantiate that with his testimony. And because of that, I think it was proper, the judgment figures were properly excluded as untrustworthy. And the court should review this for abuse of discretion. Can another person look at this and reasonably say that was proper? Giving you three records from the bank, one testified under penalty of perjury showing all different amounts due and owing. The first one was different than the last two on the amounts due and owing. All different interest rates, all different amounts alleging to be the last interest rate, which conflict with the payment history admitted in the evidence and the collection notes. I think the judge properly determined that this was not trustworthy and excluded it. Once it was excluded, they could not prove their case with competent substantial evidence, which is what's required under Green Emerald. They couldn't prove their unpaid principal balance. The amount they were seeking did not match payment history. It didn't match collection notes. They couldn't prove any other damages. He couldn't point to anything in the business records. And I had him confirm, your knowledge of this loan is just based upon your review of the business records. And he said, yes. At this point in time, I think Green Emerald is what really should control here. I don't think Leon's is actually helpful to us. If they truly wanted to unwind this unilateral modification that they placed on my client, they could have done what the Leon's case did. So yeah, our business records, we discovered this a week before trial, which again, after 8 years of litigation, I don't know how they didn't discover it. We discovered it before trial. Our business records now have been corrected. You can see the change back to the original amount. They didn't do anything. They had literally just admitted on the record, yeah, a week ago we updated these judgment figures to have different numbers. That's not competent substantial evidence. I think the Green Emerald case should control here. Unfortunately, sarcasm can't be read through a transcript. When I said that the amounts were correct, that was sarcasm. That was an issue where the court, we were going back and forth on what the alleged amounts due and owing were correct. Other than that, if the court
Mr.
doesn't
Wolf,
have any other,
what you have indicated in your brief that you have no objection to the trial court entering partial judgment on the reformation claims. Was any evidence presented for reformation, or are you now stipulating that we should reverse with directions that a judgment be entered?
yeah, so the reformation count kind of got wrapped up in the foreclosure count. We have no objection, so we would stipulate to the reformation. I think it's more of a ministerial duty more than anything, and it happens pretty frequently with closing. So I would have no opposition for a judgment being entered for the reformation. There wasn't any evidence, but again, reviewing the complaint and what I think should have been, I think it was the legal description, if I'm not mistaken. I think that should have been corrected. But I think we just got wrapped up.
But was the trial court asked to correct it at the trial?
They weren't.
Okay.
I will tell you, it's usually just a matter of course during the foreclosure trial.
Well, and I appreciate the candor on this, and I'll ask Mr. Levine the question when he gets back up. But the bottom line is the court wasn't asked to reform the mortgage at trial. I understand it was pleaded, but it seems to me odd that we would reverse and say you should have entered a judgment for reformation when the court wasn't asked at trial to enter a judgment for reformation. So that's more of a speech than a question, because I wanted to give Mr. Levine the opportunity to think about that before he gets back up.
So the only thing, as I'll conclude, is that I don't think the standard here today is that you must produce some evidence. I think Green Emerald says you have to prove competent substantial evidence, and failure to do so is cause for involuntary dismissal, which is exactly what Judge Barthel did. And if the court doesn't have any other questions, I would ask the court to simply confirm the trial court's ruling.
Very good. Thank you.
Thank you.
Mr. Levine, if you would start with the reformation issue, just so we can knock that out. My concern, you heard what my concern is. And so the trial court wasn't asked to do that. If we were to affirm on the main issue everyone's arguing about today, how do we reverse and tell the judge you're reversed and now you're going to enter an order that you weren't asked to enter at trial?
So I think Mr. Wolf was honest that it kind of got wrapped up. Everyone was arguing the foreclosure that the reformation kind of fell aside, but we did put in Exhibit 9, the warranty deed showing the error. And I will point out, we did expressly state in our motion for rehearing on page 1657 of the record to the trial judge, hey, you were still wrong to dismiss the reformation count. And so that issue of requesting reformation was at least presented to the trial court on the motion for rehearing, telling the court that, yes, even if you were right about dismissing the foreclosure, which of course we said you were not, you were still wrong in dismissing reformation since we proved that as well. And obviously, so it was preserved. It was requested of the trial court, even if it was kind of on the motion for a hearing stage. So I believe, so Mr. Wolf said several times, if I understood him correctly, he says I believe he said the 125, or it's heavily implied that the 125 is correct, that the 130 is wrong. I agree. The witness agreed. Everyone agrees. The judgment figures that we tried to get into evidence that the court said was untrustworthy, I mean, maybe Mr. Wolf was being sarcastic, but at least at the time, it appeared that everyone agreed that the numbers in the proposed judgment figures were correct. So they were trustworthy. But as a matter of law, you can't determine a record to be untrustworthy by examining the content of the record itself. And the reason you can't is because that's the role of the fact finder.
But isn't that a little bit of a problem when the witness essentially testified that the records were untrustworthy? I mean, he didn't use those words, but he said these records do not accurately reflect what occurred and do not accurately reflect the amount that we pleaded and that now we're claiming that pleading was wrong.
So I believe the witness testified what happened, and he said that the judgment figures we were seeking were correct. So those judgment figures should have been admitted, subject, of course, to cross-examination, subject to impeachment, subject to a defense case, because Mr. Wolf said he pled this as an affirmative defense. Well, if he pled it as an affirmative defense, then certainly it would have been his burden on a defense case. But he tried to get to involuntary dismissal on something I guess would have been his burden. So for that reason, also involuntary dismissal should be reversed. He mentioned the interest rate. Now, obviously, the interest rate figures on page 512 of the record that in the excluded judgment figures would have had it. But I'm guided by what Judge Atkinson wrote in U.S. Bank versus Engel. He said, however, where an interest rate is adjustable, the interest rate may be calculated using the lowest rate if that was the only proof adduced at trial. So based on Judge Atkinson's statement in this case, even if the judgment figures were excluded, you can use the minimum interest rate under the note, if that, because the note's certainly in evidence. So when you look at this case as a whole, I get it, Judge. There's discrepancies in the evidence. I understand that they gave them a refresh mod is the term the client, the witness used, not my preferred term. They recapitalized and then backed out a week before trial, which, by the way, was the right thing to do. If we had gone to trial and said we want the 130, that would have been the wrong thing to do. We did the right thing by correcting the records or updating the records and backing out the mod beforehand. Now, in Green Emerald, which Mr. Wolf heavily relies on, not just the footnote that Judge Atkinson read, but above it, it says on page 510 of Green Emerald, quote, we note that on appeal, not even 21st Century Mortgage has argued that its evidence of the amount due was legally sufficient. So in that case, the bank wasn't even arguing that their evidence was legally sufficient. That's why they lost. They kind of waived the issue. I'm arguing it is legally sufficient. And to be perfectly candid, I think I'm right. Because the promissory note is certainly evidence of the amount due of 130 something that was originally borrowed and is itself a prima facie case. The payment history is competent substantial evidence. Whether it has discrepancies on it or not, it's still evidence that the court couldn't weigh on a motion for involuntary dismissal. The witness's testimony was in without objection. Now, Mr. Wolf mentioned, oh, it's based on the business record that had been altered, but Mr. Wolf never moved to strike his testimony. So his testimony is in evidence. So when you look at all the evidence before the court, presumed true, all inferences to Deutsche Bank, no weighing, there's no view of this record where a prima facie case wasn't established.
And that brings us right to the end of your time.
So we ask that the court reverse and remand for further proceedings. Thank you, Your Honors. Have a great day.
Very good. Thanks to both of you.
Thank you.
Thank you.
And you can go ahead and hit the leave or the exit button and
Will do.
you'll be out of here. Thank you.
Thank you. Bye.
The next case is Custom Homes by Triumph.